Hi, my name is Emma Ross and I'm the Senior HR Advisor with Master Plumbers Association of Queensland. Today we'll be discussing the paid leave entitlement of family and domestic violence and what are some considerations for this leave type. So I'm very pleased to be joined by Jill Hignett, the Director of HR Law. Jill has extensive experience and knowledge in all areas of workplace law and is the founding committee member of the Queensland Law Society Workplace Relations Specialist Accreditations Committee and held the position of chairman for a number of years now. Jill is also a past member of the Queensland Law Society Court Procedure and Process Committee, and Jill has authored numerous articles and presented in a variety of forums as an expert in workplace relations law. Welcome, Jill, and thank you for taking the time to discuss this important area with us and our members.
Thanks, Emma. Good to be here.
Yeah, thank you. So I guess let's get into it. And by kicking us off, what actually is family and domestic violence?
Well, these are amendments that most of your members probably would know have come into effect this year. They form part of a plethora of new laws that surround how you are to deal with an employee. And these laws sort of marry in with existing laws, both on occupational health and safety and a bit around flexible working. So we will get into the minutiae of all of those different types of leave and how they interact. But firstly, the official definition of what family and domestic violence is, it's got a two-pronged approach. The first is that it has to be family or domestic violence that is violent, threatening or abusive behaviour, which is in itself quite self-explanatory, but this part of it by a close relative of an employee or a member of the household. So that's who the perpetrator needs to be, is a close relative of the employee, a member of the employee's household, or a current or former intimate partner of the employee. So that's part one. And then part two is that that person has to be seeking to coerce or control the employee and cause the employee harm or to be harmful. So it's really important that both of those are considered when determining whether family or domestic violence leave is to meet the minimum threshold for what it is. That being said, I will put the caveat on that there are a lot of employers that are going beyond the minimum. This is the minimum standard, but we always recommend that as these laws develop and we understand through case law what they're going to mean, people adopt it with their own processes and procedures and policy that would overlay any minimum entitlement at law. So, but it is a new concept on its standalone. It's always sat family and domestic violence as a matter relevant to asking for a flexible work arrangement, but it's always been on an unpaid basis if it was taken. So this is sort of bringing it in line to be paid by the employer in those specific circumstances.
Yeah, right. And I understand there's different types of domestic and family violence. Would you mind just explaining some of the different types, I guess, for people to look out for?
Yeah, so people obviously know and think of the physical side of domestic violence, which is obviously usually or likely to be the main component. But there are different types that exist, and you need to turn your mind to what it is when you're considering a request by an employee. Now, what the law is that it can form many different parts or different types of behaviours, and that includes, as we said, physical, which most would recognise, sexual assault or sexual abuse, again, which most would notify or understand. The others come into these areas where you might need to turn your mind to thinking about a bit differently, which is verbal abuse, emotional or psychological abuse, stalking. That's a big one that obviously can often marry in with some of the other types of domestic or violence, family violence. Financial abuse, and that's relating to, restricting money or dictating money. Spiritual or cultural abuse, that's a sort of difficult one to conceptualize, but it is obviously abuse around someone's beliefs or practices. serious neglect where there's a relationship of dependency, damage to property, technological assistance, or abuse or threats. So of pets, which again, that's one outside of the square what we'd all normally think. So when it comes back to that about the control and seeks to harm, this is where the assessment of all these different types of leave will come into play. So yeah, open your mind beyond what it is and assess each one on an individual circumstance would be my tip.
Absolutely. And I guess there's a lot of thinking around the physicalness of it, but certainly when it's more broadly like this, there's a lot more to it that can certainly impact somebody's life. Absolutely. So what are some signs, I guess, for businesses to look out for that an employee may be experiencing family and domestic violence?
So there's a fine line between obviously looking after and caring for your employees and showing that that you do care about their circumstances and invasion on someone's privacy. So I think it is a fine balance to know how you should approach signs if you see them and what you should do. So obviously as an employer, you have an absolute obligation to ensure people's health and safety. Now, what's happening at home does not necessarily refer to an employee's health and safety at work, but it often can, either by it coming into the workplace, by, say, a partner turning up at work, or by, the employee being put in situations at work which may exacerbate or bring to light those issues. So with caution, I say look out for signs and then approach it in the appropriate way that you would think that employee would like to be approached. So that could be through HR, that could be through your EAP service, reaching them out. It could be by discussions with next of kin and things like that. But yeah, you'd need to look at each scenario and see what it is. But some signs are like excessive or unexplained absences, or late to work, or, stress about leaving on time. They always can be signs about a pressure at home that needs to be be dealt with. A sudden or sustained drop in productivity. Obviously, if your mind's elsewhere on matters, it will flow on to your work performance. Unexplained injuries, obviously that's an obvious one. Social withdrawal, so yeah, from the workplace, if there's been a heightened or a definite withdrawal from previous behaviours. Frequent or unusual work breaks, they're going out on their breaks and on their phone and coming back stressed. Anxiety or fearfulness, that's obviously an obvious one. Appears distracted, depressed or overly jumpy, that's again an obvious sign usually. A lack of concentration. An inability to work or take work-related trips, that comes down to a personal pressure, and then the personal calls, etc. So these things can all obviously be signs of things other than domestic or violence. They can be just everyday pressures, and that's where I caution jumping to a conclusion about something. But on the same thought process, you can never over care for your employees, you can never care for them enough. So just checking in about their well-being and checking that they're okay by the appropriate person will help you identify it early. And obviously the earlier you identify it, the earlier it is resolved, and hopefully there's a path forward for both the employee and the employer. They get their employee back who's engaged, driven, and who you want at the workplace. So there is mutual benefits in detecting it early.
Yeah, absolutely. And I guess that key message of working in with your staff, picking up on some things that might be just a little bit out of the ordinary on their individual reactions or the way that they're presenting for work. Yeah, that's really helpful.
And I wouldn't jump to the question. I have to ask: are you suffering domestic violence? You would approach it in a caring, practical way. That may be having a female approach. If it's a female, it may be, as I said, through HR or through an EAP service or otherwise. So you can do it without putting the employee in a difficult situation.
Yeah, absolutely. So what are some of the obligations as an employer?
Okay, so in regards to the domestic and family violence or family and domestic violence leave as its own, there's a two-pronged approach to the change in legislation. If you're considered a small business, so that's less 15 or less employees, these changes don't come into effect to the 1st of August. If you are not a small business, then they've already come into effect as of the 1st of Feb. So what the entitlement is to 10 days paid family and domestic violence leave. And that leave entitlement accrues from day one of employment. So if someone commences employment today and you're not a small business, then they automatically have a right to take 10 days family and domestic leave from today. So that's a differential factor to other types of leave, obviously, which accrue over time. This is you get 10 days on employment, and then that 10 days renews every 12 months. So it doesn't accumulate. So you will only ever have a maximum of 10 days in your bank, but it's 10 days. They can take that 10 days over a 12-month period. Whether they do or don't take it is irrelevant. It then starts again at 12 months and you get 10 days back. So that's a real important thing. Don't think they have to pass probation or accrue it before they get it. They get it from day one. As I said, for small business, that paid part of it doesn't start till the 1st of August. But what's in play now before that is they're entitled to 5 days unpaid leave. So until the 1st of August, small business would have to allow it on an unpaid basis. From August, they have to meet the 10 days as well. So, but what's important to know, and we'll go through it, is how you treat that leave and how you record that leave is really very specific in these circumstances. But we'll talk about that further. As we talked about in the opening, family and domestic violence leave will come into play or be relevant to flexible working arrangements and health and safety. So everyone would be aware as what flexible arrangements are, and I don't intend to go into it in too much detail, but to say, obviously, if an employee approaches you for a flexible working arrangement, what used to be really easy, the employer just say, sorry, for operational reasons, we can't do that. The law doesn't allow that definite no with no explanation anymore. They're really tight timeframes around what you must do as an employer, what you must say if you reject or accept or propose an alternative, and that there has to be really good consideration given to that. What we're finding is post-COVID, there is a stronger argument, if I can put it that way, for flexible working arrangements, because a lot of employers, probably not so much in your industry, but a lot of employers had, work from home arrangements, had part-time work from home or otherwise. So they've got that precedent to be able to say, well, it's worked for the business. So during COVID, so why can't it work for me to meet my parental needs or my needs around assessing, in a custody battle or something like that. So tip is a lot more thought needs to go into it than it used to, and certainly a lot more written documentation and process needs to be followed. But that requests around domestic and violence leave on a flexible working arrangement really have to be taken seriously, and that have to be, in my view, a very, very good reason why you couldn't do it, and that might just be, okay, you're going through a court situation, how about for the next 6 months, it will allow you to work 4 days, and then you'll have a day to go and do what you need to do over the next 10 weeks, and then you revert back. So you can do it for a short period of time. It doesn't have to be ongoing, but that could be one way you would address it, to say you've got 10 days. How about for the next 10 weeks, you do 4 days work, you take 1 day family and domestic violence leave, and then we can assess this flexible working arrangement after that. So that's an example of how that you could, obviously deal with both. And so 6th of June was the date that those major changes came in about flexible work. So that's something, that we need to consider as we sit today for everyone. workplace health and safety, I'll touch on it. Obviously, you have an obligation to ensure work and health and safety. It comes into the workplace if, you know, as I said, a perpetrator or otherwise might visit work, or police might come on to serve papers or otherwise. But what the main issue would be is if you see an employee who's vulnerable, who is not themselves, once you know that fact, and you may be exposing them to harm in the workplace because they're at that vulnerable place. So it's really important not to think, oh, that's just a home life matter, it's got nothing to do with work. That's not true. You know, if an employee has changed considerably, they're suffering, and then, you know, their mind wasn't on the job and then they cut their hand off, or, you know, in your industry, some workplace accident happened, that would be relevant to, you know, work health and safety, and you take an employee as they are in those circumstances. So, yeah, you really shouldn't look at it in isolation, and you should consider these three heads as one.
Yeah, absolutely. So thanks so much for giving sort of, I guess, a bit of a summary and an overview of the family and domestic violence provisions. I guess now if we touch on some more specifics and go into a little bit more detail of each area, that would be great. So you mentioned about the family and domestic violence leave. So I wonder if we could just push forward and get into some of the detail of that. That would be great.
Yeah. So as we talked about before, there's the two-pronged approach to it. So it's got to be so that the perpetrator, if I can put it that way, has to be as defined, which is a member of an employee's household, a close relative of an employee, or a current and former intimate partner of an employee. So that's who the perpetrator has to be, and they have to be seeking coerce or control the employee, seeking to coerce or control the employee. Now, that's a bit of an unknown what that looks like, but as we talked about, there are many different strains of what can demonstrate or present as being coercion or control of an employee. So if in doubt, I would always take the conservative approach, which is, okay, it is that, what do we need to do? It is domestic and violence. What do we need to do as an employer? In terms of these amendments, as we talked about, so 1st of Feb, we're in them as if you're a large employer. You're not yet there if you're a small employee, but that's the minimum basis. But what I would be recommending to your members is that they look at these entitlements, and they look at developing a policy around how are we as a business going to handle it. That policy could be a manager's guide that you don't necessarily have front of house for everyone to see, but given that it's a new area, given that there's going to be need for interpretation, it's really good for people to have consistency over that. So I would be developing a manager's guide for dealing with it, and obviously then a policy around what you as a business are doing to combat, you know, issues of family and domestic violence leave. Yeah. So, what would the employee need to take the leave for? And because that's the I suppose third aspect is it's got to be not practical for them to do so outside of work. So that means not only is it by the perpetrators we discussed, not only is it coercion and control, which meet the definition of family and domestic violence leave, it has to be an act or a thing they need to do which they can't do outside of work. So some examples would be like making arrangements for their safety. Obviously, if there was an event at home, they've gone to a shelter and then they need to be able to get a place for their family. That's likely to need to happen in work hours. So that would be an example. Attending court is probably the biggest example, or a police station. They're the two where that would likely have to be would be during working hours if they're a full-time worker. Attending counselling, that one's a bit more subjective. Like an employee is possible to get counselling outside of work, but again, you might and you will need to deal with that on a case-by-case basis. Attending medical appointments, again, if it was with a GP, maybe you could do that outside of work. If it was the psychiatrist or psychologist, maybe you can't. So you need to balance all of those things, and again, think about, I'm talking about the minimum. You know, you as an employer can go beyond the minimum. You might say, listen, there's no need for you to justify to me that you could do it outside of work. I'm happy to give it to you. You know, you as an employer can go beyond the minimum, which is what we're sort of seeing is the concept. Probably a lot of employers are going to adapt, which is a good thing. It applies to everyone, so your full-time, your part-time and your casual, so that's important to know. And again, from day one, so you hire a casual employee today, they are entitled to the 10 days even though they're a casual from day one. And we'll talk about what considers normal pay, but yeah, the three versions, full-time, part-time and casual, will all be entitled to it.
So I guess in terms of the leave entitlement, is it applicable for all employees, and does that include the perpetrator?
So this is a question, obviously, that is important to know the answer to, because you will often get people coming at family and domestic violence leave from a different angle. The short answer is no, it will not apply to the perpetrator, and that is because of the requirement that the employee or a member of their household is experiencing family and domestic violence leave. So it's got to be an act against that person or an act against someone who qualifies as an immediate family or household to be considered for domestic violence, family or domestic leave. That being said, you know, it is often the case that two people look at it very differently, you know, or they're both the perpetrator and the victim. So in circumstances like that, the waters are muddied a little bit, but you may want to dig down a bit further in the evidence you require, which we'll talk about. You might not just take it on face value if they say that. You might say, well, I need some, you know, evidence from the police or some evidence to prove that, yes, you are suffering or experiencing that in order to access it. So again, case by case basis, and I wouldn't assume the role of making that interpretation as an employer. What you should do is say, do I have enough to satisfy me that it is? If I don't, then I'll ask for more evidence to support that.
Just, I guess, further to that, if the perpetrator did come to their employer and I guess say, hey, I've done something really bad last night, and I want to get some help for myself, would that then change that they could access it, or would it still be because they've been the one inflicting it versus the experiencing it?
Yeah, so I think that's the fine line of, if they come to you and say, we had a big fight, I punched her and he punched me and we both went at it, then that has to be determined, well, do they hold those dual roles of, one, being the perpetrator, but two, suffering it as well. So in a circumstance like that, I think they would have an argument, even though part of it is only them as experiencing it and part of them is them being accused of doing it. There could be some entitlement on both sides, but I think that would be rare. You know, mainly I would say, if they ask it, the first thing you ask for is evidence from the police officer if they were called, or the hospital if they were there, and you can get some sort of satisfaction as a reasonable person test. Would a reasonable person be satisfied that the employee is experiencing it? As I said, though, some employers are going above and just saying, listen, if you suffer anything or if you're part of that, I'll allow you to have it. So you can go above the minimum, but I think if they're just the perpetrator, they wouldn't be able to access it, the minimum entitlement, unless you, the employer, agreed.
Mm-hmm. Yeah, great. So you touched on this before a little bit, but how much leave does an employee receive? And when does it start for businesses, being that it's I guess, new in terms of a paid leave entitlement?
Yeah. So as we talk, there's two different prongs or two different levels that are coming into play. The first is already in play, so that if you employ more than 15 people, you already have to give a family and domestic violence leave. And that happened from 1 Feb. So you've got to work out when you'll tick over to the new day. And what we're saying is you make it 1 Feb. So 1 Feb, they'll renew every 12 months for their domestic and violence leaves coming into play. So you get 10 days, you get it from day one. So if an employee started today and came to you and said at lunchtime, I'm suffering it, you would have to give them that access to 10 days from there. So there's no way to get out of it. There's no way to contract out of it. It is in play from the 1st of Feb. As we talked about for small business, that's the 1st of August. And what's in play instead is unpaid 5 days till now. So unpaid 5 to the 1st of August, then they will meet in with the rest of the business with that 10 days within 10 days within a 12-month period. But again, there are policies and employers are considering whether there might be an ability to take either ex gratia leave beyond that or to take unpaid leave beyond that. That could all form part of your family and domestic violence leave policy, if you liked. So, you know, a lot of people are waiting maybe to see what happens in case law and how this develops. But I really do think having a policy will help an employer be able to help their employees more than just the minimum.
Yeah, absolutely. So talking about the actual payment, what does an employee get paid when they take the leave? And I guess how can they take the leave?
Yeah, so this is again a bit of a unique thing to this leave and a little bit different to how other leaves are taken. So what you are required to pay them is their full hours they would have been paid if they hadn't worked, sorry. So what is important is it's not just base salary. So say you had an employee who worked on a Saturday and got Saturday loading, obviously, for working a Saturday. And then they came and said, I need to take a domestic and violence leave today because I need to do X, Y, Z. They would be entitled to what they would have got had they worked that shift. So it's not like you go back to base salary only. They get what they would have been paid had they, what is their full rate of pay for the day they took the leave. So that includes obviously incentive payments, your loadings, your monetary allowances, your overtime penalties. So again, if they said, oh, listen, you're going to have to work overtime tomorrow, so you're rostered to work 8 hours, but I'm going to need you for 12, and then they take the leave, they'd be entitled to that 12 hours. So that's really important, that part of it, to be considerate of what is their full rate of pay, what would have they had. So they can't just say, oh, well, normally you give me overtime, so I get it. It'd have to be that it was, i.e. rostered or contemplated. But if it was rostered or contemplated or the usual, it has to be at that full rate of pay.
Yeah, right. And so they can take it in a whole 10-day block or separate periods of 1 day or more?
Correct. So yeah, the minimum is 10 days, 5 days, 4 days, 3 days, whatever, down to a single day. But the employer can agree, and again through policy or beyond the minimum, to take half days or 3 hours, you know, which is often what you need. If you need to go see a lawyer, you could say, I need just the afternoon off. If I could, I'll come to work in the morning. So that benefits the employer for agreeing to that. And also it helps the employee, you know, make those 10 days last longer. So I would implore employees to really think outside the minimum and say, okay, is it really going to be disadvantageous to us to allow half day? If it is, because I still have to get an employee to replace them, so I've got to put someone on, and I can't give an employee half day, so it just doesn't work giving them a half day. There are business reasons why you wouldn't, but most employers we're finding are considering it on a case-by-case basis, and that's all you've got to say is on a case-by-case basis we'll consider periods less than a day.
Yeah, great. So does an employee need to accrue the leave before being able to use it?
Yeah, and that's a no. So it's the one type of leave, as I said, is you get it on day one. You don't accrue it year to year. So you don't, like annual leave or sick leave, you get that from year to year to year. Your bank just keeps accruing more. That doesn't happen with this type of leave. It goes back to 10 days at the end of it, but it will be for 10 days straight up, no qualification needed, no anything. They just get it if they can make the threshold of proving it was the perpetrator we talked about, and it meets the definition of coercion or control. So once they're satisfied, they get it. And then, as I said, it's really important, and this is what employers will need to think about is, and we're going to get into it, is how you record that, both on a pay slip or visibility, but also back of house. There are specific rules around that, but it would be important that the employer would be able to say, what's the 12-month trigger? Is that, the 12-month trigger is different for every employee. It's at 12 months of the anniversary of their employment, they get it. But what that means is back of house, you're going to have some sort of record that is clicking it over to restart on that day. And if everyone has a different day, you'd have to be restarting it on that different day. So administratively, there is a real way an employer is going to have to deal with this back of house, which is pretty unique to this kind of leave.
Yeah, absolutely. So I guess in bringing in some of the other leave, does an employee need to exhaust their other leave before being entitled to use this leave? So, for example, their personal carers leave, they need to use that first.
And that's a big misconception about a lot of things, about other types of leave, but also about this leave. And the unequivocal answer is no, they don't have to exhaust any of those leaves. Often, obviously, personal carers leave can often be part of or relevant to family and domestic violence leave. So previously they would have taken it as a personal leave or carers leave. So they do not have to exhaust all of those, and it's got to be looked at as separate to those. And what you will find and employees will do is they'll access the 10 days, which doesn't accrue to year, and preserve as much as possible the personal carers leave, because that does accrue year to year. So, and that's understandable. So what an employer needs to also understand, though, is if an employee is out on personal carers leave or is in fact on annual leave or long service leave, in any of those types of leave, they can turn around and say, sorry, I need to convert Monday, Tuesday, Wednesday to family and domestic violence leave because I was dealing with matters I could not otherwise deal with. Again, they've got to provide the evidence. Again, it's got to be the perpetrator we talked about, but they are entitled to have that leave converted. So there's a big misconception about that, because it's still the same if you're on annual leave and you go sick. Technically, you can tell your employer, I'm actually sick Monday, Tuesday, Wednesday, convert my annual leave to sick leave. And as long as they've got the evidence, you as the employer are required to do that. So I think it's important to look at it standalone, but also look at it with those other forms of leave, and certainly don't be saying anything like, I'm not giving you those 10 days until you've got no sick leave, because that's just not, or personal leave, that's just not the case.
Yeah, right. And how much notice does an employee have to give?
Yeah.
And can an employer ask an employee to provide evidence?
Yeah.
And what evidence?
This is one that, again, is unique to this kind of leave that will be sought. So unlike other things, obviously, as you know, if you take annual leave, there's provisions around how much that's got to be agreed between the employer and employee, and there has to be some mechanism around time. With this leave, there is no requirement to notify within certain periods, and obviously that's born out of what this leave is about. Is it's often leave, it will be leave that's not planned in most circumstances. So if it can be planned, like i.e. I've got to attend a court date, then obviously the employee would be best served saying that to the employer as soon as possible, so alternate measures can be put in place. But 90% of this leave will be taken, ad hoc and with no notice. So there's no requirement for notice by time, but there is requirement for notification. So that is, there is a positive obligation on the employee to explain to the employer it is, and to provide sufficient evidence for the employer to be satisfied that it does meet the qualifiers of what this leave is. So what would that look like? Like, as I said before, it could look like a letter from the police that confirm, a domestic violence event occurred. It could be a letter from the employee's lawyer who says, yes, this is what's happening and this is what leave she needs to take or he needs to take. It could be a letter or statutory declaration from the employer themselves. So they could provide you with a stat dec saying, I'm really embarrassed, I don't want to talk about it, but this is what's happened. I certify it's true and correct. It's obviously a legal binding document. So they're all things that could satisfy on a reasonable person test, yes, it is family and domestic violence and therefore they get the leave. So again, case by case basis, again, most employers are going above and beyond. And when I say that, they're taking their employee, you've got a good employee, they come and tell you this, you might just say, I'm happy to take your word. I don't need any evidence beyond that. But then obviously if it was a different scenario where maybe you do have questions around whether it's legitimate, then you would. So you don't have to have the same request for everyone. As I said, case by case, the way you deal with Mary, who's been with you for 20 years and never had an issue, may be different to how you deal with a new employee who starts today and asks for it. Those thresholds may be different, and on a reasonable person test, that's understandable.
Yeah, absolutely. So in terms of I guess recording this leave type, can a business list down on the payslip family and domestic violence leave?
Yeah, so this is a really big issue from an administrative perspective and also an acknowledgement perspective. You, under no circumstances, are to record it as family and domestic violence leave on someone's payslip. So married with that is there are extenuating requirements or extensive requirements to maintain confidentiality. So once you get a disclosure from an employee, that's where I talk about a manager guide or a policy really is necessary, because you can't just go sharing that with everyone. And not that someone necessarily would by purpose, but by default, I don't know how to deal with this. Let me ask, her manager, and then let me ask HR, and then let me ask. If you do that, you're breaching confidentiality. So it's really important that the disclosure happens to one person, and that there really is some lockdown about the information, that where some information is going to be stored about this and what it's going to say. As lawyers, we initially thought there would be an ability to maybe put special leave on your payslip, so to be able to identify it still as separate but not. But they've come out and said no, it can't. Your payslip has to look like what it would look like if I was at work this week. So if I was at this work this week, I get ordinary pay or salary or hourly rate plus your overtime, and that's what it has to look like on the payslip. So anyone who picks up that payslip, including payroll, have no visibility at all that it's anything other than that. So the effect of that, what that means is the employer has to have some back of house method of tracking this leave and understanding where it is in terms of, where they're at with the 10 days and how much they've taken and what the evidence is. So we're suggesting there needs to be some sort of back of house recording of it, but your payroll system has to integrate with that. So it is proposing at present a little bit difficult, because if you add it to your annual leave balance or your sick leave balance, then that will accrue over. So it does have to be recorded back of house some way that it doesn't accrue over, but that it doesn't identify. So payslip doesn't identify. You would be able to have a file under their name that is locked down that maybe talks about the accrual. And again, I'd record it there as special leave, but it's not on their payslip. It's not visible to everyone. It's only visible to, a certain number of people who need access to it, who can track, okay, they've taken 5 days, but guess what? The 12-month clicks over, so we put 5 more back in the bank, so there'd have to be that recording somewhere back of house. So it is really important. I'd be thinking about that now and not when you get your first case, because that's going to be a real issue. And if you breach it, there are significant penalties. These are civil remedy provisions of the Fair Work Act. So what that means is they're a part of the National Employment Standards that apply to everyone. And if you breach them, there are penalties that apply of approximately 80,000 per breach for a corporation. And I think it's 11,000 per person. So they are significant breaches if you do this. And that's where we think we'll see breaches, is mistakenly putting it on their payroll or mistakenly putting it for visibility. So yeah, although I don't think they'll be brought to hand or penalised significantly straight away, because everyone's trying to get used to how to minister these, it's really something you need to turn your mind to. If you can take one thing out of today, it would be that, is find a way to be able to be recording it and storing it that still complies with your obligations.
Yeah, absolutely. Because I guess, because of the way that the domestic violence can occur, it could be that financial impact that the perpetrator is the one receiving the pay slip. So they don't want to be, you don't want to inadvertently alert them to it, that the employee is sort of seeking their own action to try and get away from their situation.
Yeah, that's it. And that sort of applies to about explaining where the employee is, like if the employee's not there, all I would be simply saying is they're taking some leave, they're on leave these days. I would not, you obviously cannot say what it is, but these are all the practical applications of these changes that an employer should turn their mind to, because you need to explain it. You can't just have Mary not turn up to work today, but you've got to be very, very careful who you let know what kind of leave is. And to me, I would be locking it down to 2 people, at maximum, hopefully, the HR manager of the division and or a director or otherwise, but really have this locked down and make sure there's no inadvertent disclosure. So right protect, like if you store it in a personnel file, I'd put a right protector over the special leave component that only people who have the password can get to it. All of those things, I think you've really got to go lock down this information, which is so different to any other entitlement an employee would have.
Absolutely. So I guess in exploring this a bit more, how does a manager have conversations relating to requests for family and domestic violence leave, given that it is such a sensitive area and such a confidential area, that managers might just be a little bit nervous about what they say or might say or might not say?
Yeah. And fair enough, I say, this is an area now that has always been considered a private thing and something that you as the employer don't have necessarily the right or the need to know. But obviously when we're satisfying ourselves that it is, you may need to know. So I think the number one thing, as I said, is there should be designated people to deal with this. It shouldn't be the manager dealing with it. A practical on-the-ground manager should not deal with this kind of leave. It should be someone who is equipped to A, have access to the restrictions that we've talked about on the leave, but B, have, I would implore, send them on a course. There's so many courses happening now about how you can deal with these things, and together with mental health, together with other, things that are developing in employment law now and employment scenarios, because being a manager doesn't equip you for this, and I think it really does require someone who has had some sort of training in that area, like we do with first aid. There's first aid officers who understand the injury side of things. I think there needs to be someone in the business who understands psychological and this kind of leave, but again, case by case, really take it seriously. That's the one thing. We've already had some employers saying, oh, well, this is an employee takes leave, they take a sick day every day, 6 day, as soon as they accrue a sick day, they take it, and this is just another thing on top. You cannot approach this in that way. You've really got to be mindful of, I'd be taking the view it is true, and what do I need to satisfy myself that it is true? You know, what evidence do I need from those scenarios? So obviously empathy, these are all things that you would expect someone to do anyway. Take a calm and reassuring tone about how you're dealing with it. Obviously, they often come to you heightened in those scenarios, so it's important to sort of step back and see as a business, what are my obligations to support this employee, and then what am I prepared to do above and beyond those obligations to meet what they need to happen. So you know, encourage them to talk up. As I said, if you had an officer that they could talk to, EAP service, I think, is really important in this space, is to refer them to EAP to get that support. You may want to say, listen, go talk to a counsellor, and the EAP service will cover that, even though it's not strictly out of work. We value you. We're happy to pay for 3 or 4 sessions of that. You know, there's ways to think and support them. But there really is, you know, you've got to be look at it as an individual basis. And I wouldn't be taking the view it's not true, you've got to prove it to me. I'd be taking the view it is true. What do I need to satisfy me that it's true? And then obviously not delving down too much. You know, if an employee came to you and said, I suffered domestic violence last night at my home. My husband physically assaulted me and the police were called. To most people, that would be enough to be disclosure. And you might want to say, could you just get a letter from the police to confirm that? And that's okay. I wouldn't be saying, so what did he do and where are you going and what is your plans? You know, they don't have to disclose that, and you don't need that to issue the leave. You know, obviously, if they want to talk to you and you're comfortable in doing that, you can. But I think it's really important to ask just as much questions as you need the answer to not invade people's privacy, because this it requires personal disclosure beyond what other types of leave do, but there needs to be that balance between what you need to know and what the employee is comfortable in telling you.
Yeah, absolutely. So thank you so much for answering some of those questions. I guess we've got a bit more practical scenarios that I just wanted to run through with you and get your opinion on how it could happen and sort of, I guess, some of the situations that might come up in sort of daily work environments. So the first one is an employee's household member has a violent partner who does not live in the same house as the employee.
Yep.
So is my employee then entitled to leave and to provide support to their household member?
Yeah. So again, we're looking at this two-pronged attack or a test. The first has to be that it's got to be violent, threatened or abusive behaviour by a close relative of the employee. So a partner does meet the definition of a close member of the employee's household, or a former or intimate partner. And then the second part is that they seek to coerce or control the employee and cause them harm, to be fearful. So in regards to this scenario, it would be that you would be obligated to consider this leave, and you should consider this leave. However, if it isn't that definition of close relative or a member of their household, then it wouldn't be. So in this scenario, it really would depend about the violent partner isn't in the household, but are they still considered a close member or close? So if they satisfy one of those, they'd be sufficient to be considered domestic or family or domestic violence leave.
Yeah. So the next one, an employee's partner has been accused of family and domestic violence from an ex-partner, which I guess is causing stress on the employee and obviously the partner that's been accused. Does this situation fall under family and domestic violence, even like in the circumstance that it's the partner being accused of it with no evidence or nothing that the employee is immediately experiencing?
Yeah, so then that comes back to, as I said, that part of the test that I think is open to maybe not understanding. It's got to be against or towards either an employee or a member of their household or otherwise. So given that the partner is alleged to be the perpetrator, it isn't towards him, and therefore your employee wouldn't be allowed leave because she's supporting someone who's being accused of it, as opposed to who has suffered it, or is alleged to have suffered it. So in those circumstances, no. But again, I implore employers to maybe put a light over it, that, you know, each individual circumstance would be unique to that. So, you know, there may be circumstances where you'd want to go above and beyond, but in terms of the definition, it will not meet that definition.
So if an employee has used all of their family and domestic violence leave in sort of that 1 10-day block, but then comes to work advising that the partner has been violent in some way, can they access family and domestic violence leave in advance for their next 12 months? Or if not, what type of leave would they be on?
Yeah. So this is a good one, because I think it will be a scenario that will come up. You know, someone may need to be off work for 2-3 weeks in a block. So technically they're entitled to their 10 days paid. Then they could, in terms of minimum entitlement, then go on to unpaid leave, or they could take it as carers or personal leave if it satisfies that, or they could do it as a flexible working arrangement, which is what I talked about before, that maybe they work from home for that period, or they work 4 days and have 1 day. So they can mirror it in with other awards, but they're not entitled to take it in advance. But the employer can give more than that entitlement as well. And I think the only bit of caution will be, if you think you can give it in advance, if you do that, I think there still will be issues about compliance with the legislation. So, you know, it'll be similar to, you know, people who cash out annual leave when you can't. You can, if you do it, you can't do it. So they still have that right to annual leave at the end of their employment. It'll be similar to that if you give it in advance, I don't think you'll be able to say, well, they've used it up, so they can't get it in the second 12 months, because that's not what it says. It says it rebounds at the 12 months. So I certainly wouldn't be considering giving it in advance. I'd be considering paying it as more leave, unpaying it, giving them personal leave, letting them take annual leave, letting them do a family work arrangement. And again, individual circumstance and assessment for that. So I think what it's important for an employer to understand is to be fair, they don't have to implement the same measures for everyone. You know, there may be different measures depending on the longevity of the employee's been with you, the type of what the employee's disclosed to you and what they're suffering, what the employee needs and what their needs are, what the business needs in those circumstances. So it's really important to agree to assess this on an individual basis. And as long as you're meeting the minimum entitlement for everyone, you can give beyond that.
Yeah, that's great advice. So another scenario is that the employee is confided they are the perpetrator, and I guess as a business owner might be concerned for other employees' safety and not necessarily sure they want to continue to employ this person, given that they now know this information.
Yeah.
What should businesses do?
Yeah, it's a difficult one. Again, the employee should know about it in the first instance, but all the employer can control is obviously the disclosure of information from the employer. If the employee is going around to everyone saying this is what's happened, well, they're all going to know about that. Or the ex-employee, you know, you often find them contacting the perpetrator's friends or work colleagues and telling them. So when it's out there, what you as an employer have an obligation to do and ensure is everyone's health and safety. So the same exists like at present for, say, if someone had been convicted of a sexual offence and then people in work know about that, we often find employers coming to us and saying, well, you know, no one wants to work with this person because they've been convicted of it. You as the employer only have the right to enforce it to the extent of health and safety. So if this domestic violence event and this perpetrator was specific to the employee, to his partner or wife who doesn't work for you, and there's been no evidence of it occurring at work, or likelihood or reasonableness that it could occur at work or towards anyone else, you wouldn't have the right to say, well, I'm standing you down, or you can't come to work, or otherwise. You don't have the ability as an employer to dictate that. You only have the ability to ensure health and safety. So if this person had a violent episode at home against his wife, and then he came and had the same at work, or continued that, then 100% you'd be sending that person home. They wouldn't be going on domestic violence leave. You would be standing them down pending an investigation into what they're doing. And if they're not fit to be at work, then they're on personal leave, paid or unpaid, until they are fit to come to work. So yes, you make it your business if it's a risk to your employees' health and safety, which includes the perpetrator. So say, for example, the perpetrator is alleged to have happened, but then he spirals or she spirals into mental health issues and depression, then that would bring it in the workplace. That employee would have to go out and be assessed, but that would be personal leave, not domestic or violence leave. But again, case by case, again, you need to contain it. But as I said, the area that I see could be an issue that arises is the same as you do with if employees say, I don't want to work with this person because he's engaged in domestic violence against his partner. Unfortunately, that's not necessarily enough for them to say that, and you've got to find a way to satisfy your employees that you're looking after their health and safety, but not breaching anyone's right, which is innocent until proven guilty, and that there are matters outside of work in most circumstances. So it will be a difficult balance. And all the while keeping confidential as well. So if an employee came to the employer and says, I know that, he bashed his wife last night, or physically assaulted his wife, you as the employer aren't allowed to disclose what you know, because the employee's taken the leave. So I'd be trying to, again, if that's where you've got defined officers who deal with this, defined people, you need to shut that down as quickly as possible and make sure that there aren't any inadvertent disclosures of what you, the employer, know.
Yeah, absolutely. So another scenario might be an employee's partner is particularly violent, has come to work while the employee is on that family and domestic violence leave, and they're demanding to see the employee. I guess from a business perspective, how do I protect my other employees without breaching the confidentiality of the employee affected by their partner, and also protecting the employee's privacy?
Yeah.
So not necessarily, like we sort of touched on before, disclosing, yes, they're on leave, family and domestic violence leave, not disclosing that specific.
Yeah. And that, so I think there's two things then. It's one, the health and safety of your employee whose partner has come on. So your partner doesn't work for you, but they've come on. It's how do we ensure their health and safety? And that would involve obviously health and safety obligations, but also this family and domestic violence leave. It might be, okay, you can't be at work because he's going to keep turning up to work. You want to go into, hiding or something, then you could work from home for that period. Or it could be express instructions to front office to say, if anyone comes looking for this person, you're to put it through to me and say they're not available. Or so you'd have to take measures to stop it, but it would then bring it into being a work matter, because if he turned up to work and displayed violence, then your other employees are at risk of health and safety. Their health and safety is at risk. So you've got to approach it then from a domestic and violence leave perspective and requirement to keep confidential, but also a workplace incident that has occurred, and that you have to have measures to put in place to make sure people's health and safety. So it will be difficult to balance it in those circumstances. My suggestion is you separate the two. As I said, okay, Tom is looking after your leave and what that entails and what evidence you have. We're investigating this workplace investigation over here, and measures will be taken about that. And it'll be limited to what he did, what the partner did when he came to work. So, it'll be learning as we go and making sure wherever possible there's no disclosure, but areas like this will morph over, and there will be circumstances where you're going to have to think outside the square a little bit.
Yeah, absolutely. And I guess as you touched on before, case law is going to come into this more as sort of the more businesses, and certainly when small businesses come on board from 1st of August, that will, I guess, iron out some of these specifics and work on some of the particular scenarios as well that are sort of unknown at this stage.
Yeah, very much so. And you know, it's important for an employer to also understand those ongoing changes, because it will, I think, hopefully we might even get some guidance in terms of a guide from the Fair Work Ombudsman or otherwise. They do have one on the website at present, but it's really covering what we're covering today. But there is talk that there'll be a more in-depth, you know, policies and procedures around it. And certainly after this, your members can get access to a checklist, which will be really good for them to come back to basics and be able to say, this is what I need to make sure is happening at a minimum.
Yeah, that's great. Yeah, thank you so much. We'll make that available on our website.
Great.
So absolutely fantastic. Really good information there, Jill. Really good practical aspects to it as well, because obviously this is being that it's paid, it's sort of a new type of leave, and so there's some complexities around the administration of it. But thank you so much for your expertise and for joining us today. And certainly for our members, if you've got any questions regarding this area or anything else in relation to HR, please reach out. Thanks so much.